Hello, this is Bill Erhart at Estate and Elder Law Services in Wilmington, Delaware. I'd like to talk to you this morning a little bit about trust-based planning and incapacity. Trusts have been used for the better part of a century by estate planners to reduce or eliminate estate taxes. Trusts are also used routinely by estate planners to avoid probate. Probate is the process of taking title out of the name of the dead and placing it into the name of the living. If you have a will, you are certainly going to go through probate. But trusts can also be used to manage property during a period of incapacity, and that's often overlooked. The trust maker has the ability not just to name who the successor trustee is going to be, but also with proper design set out the guidelines and instructions in the trust, how the trust maker is to be cared for during his incapacity, whether it's permanent or whether it's temporary. For example, instructions can be left in a trust to prefer home care over out-of-the-house care for the incapacitated person. The trust can state how and when assets are to be used for children, grandchildren, or other persons that the trust maker might be concerned about during incapacity. And the trust can also set guidelines how the spouse is to be cared for when the trust maker is incapacitated. If you haven't planned, or if you don't use a trust, there are two things that are going to happen, or two things that are going to be used. One, if you have no plan whatsoever and you become incapacitated, then a family member is going to have to go to court and seek to have a guardianship imposed over your property and yourself. As we all know, court proceedings are time-consuming, they're expensive, they're emotionally draining, and a guardianship subjects your property to court supervision during the entire time that the guardianship is in effect. It's very limiting and requires the guardian to continually report to the court and to get permission from the court to do any major adjustment of your finances. The other instrument that's available is the durable power of attorney, which is frequently used. Durable power of attorneys appoint agents to manage your property while you're incapacitated or absent. But powers of attorneys do not set out the specific guidelines that a trust can set out. Powers of attorneys, as a practical matter, can be very cumbersome to use. When you go to the bank to use a power of attorney on behalf of the principal, the person that created the power of attorney, very often you have to go ahead and sign an affidavit or prove that the principal, the person who created the power of attorney, is still alive. Every time you use that power of attorney, you have to show frequently that that individual is incapacitated. Trusts are much more flexible. Trusts are much more like a dimmer switch, or that you can adjust on a sliding scale. A power of attorney is like a toggle switch. It's either off or on. Either the agent is using the power of attorney or it's not. But with a trust, if you're the trust maker, and if you have named yourself as trustee, if you wish, somewhere along the line, you can add a co-trustee, someone who can assist you. Very often, if dad has a problem managing the checkbook, doesn't mean that the checkbook is taken away from him, or doesn't mean that he needs to go in a nursing home. It means he needs some kind of an assistance. A co-trustee can provide him with that assistance. Mom burns a pot on the stove, doesn't mean she needs to go into the nursing home. It means she needs some kind of assistance. Trusts are very good instruments for providing that type of assistance by naming a co-trustee. If you want more information about trusts and how trust-based planning can help you plan for incapacity and help keep you in control longer, please give me a call at area code 302-651-0113. Thank you for your attention.